If you and your spouse have served in the military, I thank you for your service. And today I'd like to discuss a common myth about the division of retirement on divorce. My name is Laura Hurd, and I'm an attorney who has helped military members navigate divorce in San Antonio, Texas for many years. I've been practicing law here since 1987. I often hear people who have misinterpreted or been misled about the 10-10 rule on military retirement. They think because they have not been married for 10 years while their spouse was in the military that they're not entitled to part of the military retirement. And that's simply not true. What the rule says is that you're not entitled to have the military divide the retirement for you. The military is not going to send your portion to the non-service member spouse directly. However, that doesn't mean you can't get it. In Texas, anything that was earned during the marriage is community property. So, for example, if you are the wife and your husband was the service member, your husband retired after 20 years of military service, but you were only married for 5 of those 20 years while he was in the military. Essentially, you were married for a fourth of the time, the total time that he was earning military retirement. So approximately a fourth of his military retirement then is community property. And half of that, a half of a fourth is an eighth, would be your portion. You're entitled to an eighth of his military retirement when he starts to draw it. And what happens is you get a court order that says that he is required to send it to you as soon as he starts retiring. Then he has to put together an allotment, automatic deposit, or send you a check every month for your portion of his military retirement. So even though you've only been married a short time, while he was earning military retirement, you're still entitled to your community property portion of that retirement, even though it was less than 10 years. I'm Laura Hurd. I'm at www.ldhurd.com.